However, recointions has been fairly heavily criticised, and it's been distinguished in at least 2 cases, though never actually overruled. In spite of that, we have to wonder, I think, whether the case should be regarded as correct. For example, in Inland Revenue Commissioners against the Educational Grants Association, the issue wasn't quite the same as in cointion, and therefore cointion could be technically distinguished. What happened there was that you had an educational charity, which clearly was a valid charity, but the trustees had exercised their discretion in favour of employees of the Metal Box Company to the extent of something like 75% of the income. The Court of Appeal held that the exercise of discretion by the trustees in this manner was ultra vires, that is, that the payments out were ultra vires. No doubt was cast on the validity of the original trust, so the issue that had arisen in cointion did not arise here. It was therefore possible to distinguish cointion, though it's pretty clear, I think, from the comments both in this case and in the Privy Council in Kafur before it, that cointions is probably going to be regarded as wrong if ever the issue comes directly before the courts. Before we leave Oppenheim, we should also perhaps consider one other issue, which is this. The potential or possible beneficiaries might have been 110,000 or related to 110,000 employees, but it by no means follows that merely because that is the range of potential beneficiaries, this was also the range of people who would actually be benefited. Suppose, for example, the trustees, who had an absolute discretion in Oppenheim, exercised their discretion to pay, for example, 10 or 15 or 20% of the fees of those people who were educated in independent schools. Now, in the nature of things, this is not going to benefit all the employees in the company because they would still have to stump up the remaining 85 or 90% or whatever. The reality is that the number of people who are going to be benefited in reality is going to be quite a small proportion of the employees of the company. And maybe this is another reason, that is to say, the width of the discretion, the fact that the trustees could exercise their discretion in this way, maybe that is another good reason or good justification for the actual decision in Oppenheim and in other similar cases. The cases that we've looked at so far are all educational charity cases to which the Oppenheim test clearly applies. Now the issue then is, what about the other heads? Lord Symonds thought, this is from Oppenheim, that the test, the personal nexus test, applied to all the heads of charity apart from the poverty head. As we've already seen, he thought that the poor relations cases should be regarded as anomalous exceptions to the principle. It is now clear that the personal nexus test does not apply to poverty. The House of Lords held this in Dingle and Turner in 1972. You may recall that this was the case in which Lord Cross bemoaned the fact that a single test applied both to tax advantages and also to validity. Nonetheless, that is the situation, it does. The position with poverty charities is, however, that the beneficiaries must be a class of people, not simply an individual or group of individuals. They have to be at least of sufficient width to be a class, or a section of the public, if you like. This being held in the Court of Appeal in Re Scarisbrick in 1951, a decision which was approved by the House of Lords in Dingle and Turner. Scarisbrick itself concerned a trust for relations of a family, and that was thought by the Court of Appeal to be sufficiently wide. The Master of the Rolls, Evershed, thought that the poor relations cases might be justified either on the basis that relief of poverty is sufficiently altruistic in itself, or that they're simply an exception justified simply on the basis of history. Under the fourth head, there's never really been any doubt that there's no presumption of public benefit and that a strict test of public benefit applies. What is not entirely clear is whether it is even stricter than the test under Head 2. Inland Revenue Commissioners and Badley concerned a trust for provision of facilities for poor Methodists living in West Ham and Leighton. Now, only Lords Symonds and Somerville decided this case on the basis of public benefit, and Lord Reid dissented altogether. The other two judges simply decided that this was not within Head 4 in the first place. You may remember that there was a fairly substantial social and recreational element to this trust, and that was one of the reasons, or the reason at any rate in the view of all but Lord Reid, why it failed. But in addition to that, the class was not considered to be sufficiently wide. It was a class within a class. It was also a restriction that was in a sense irrelevant to the provision, which was essentially, as I say, religious, social and recreational. Now it may be that this isn't really any different from an application of Davis and perpetual trustee, admittedly a slightly later case, that we looked at earlier. The class is in a sense similar, it's limiting to a class within a class. But both Lord Simmons and Somerville appear to have accepted that a stricter requirement applies to Head 4 even than for Head 2. Of course it's a public utility head and public benefit is essential to the head. It may also be that even within Head 4 there are different criteria for public benefit depending on precisely which type of purpose it is. After all, one of the issues in Badley was that the restriction to the poor Methodists living in West Ham and Leighton was irrelevant to the purpose. That will not necessarily be the case for all purposes. In the case of religion, the idea of public benefit is pretty well tied in with the idea of advancing religion, in the sense that religious services, practices and so on have to be public for them to be charitable. The leading decision is Gilmore and Coates' decision of the House of Lords in 1949, which concerned prayers in a Carmelite priory. The nuns completely shut themselves off from the world, and although they prayed for other people, no public benefit was regarded as proved in this situation. We saw in an earlier lecture that in Re Hetherington, celebration of Catholic masses in public was sufficient, but the celebration of the same masses in private would not have been. In that particular case, the gift took effect as a charitable disposition, but the trustees were constrained to use any money from it only in relation to public masses. And in Le Crène Clark we have something similar, in this case relating to faith healing, but the faith healing was in public. We also know that the requirement for advancement is not sufficiently great. It is sufficient, for example, in Neville Estates and Madden, as we have seen earlier, that the recipients of the benefit communicate in the community or go about in the community. It is sufficient, in other words, that they advance religion by example. And clearly, since that was charitable in Neville Estates and Madden, there must also have been sufficient public benefit in that case as well.